The Anambra State Local Government Administration Law 2024 was made to operationalize the Supreme Court judgment. And I'll tell you why and how. In a nutshell, fundamentally, if you read or have read the Supreme Court judgment, the lead judgment was delivered by His Lordship, Justice Emmanuel Agim. It was very clear, Justice of the Supreme Court, that all monies meant for the local government must go direct to the local government and must not be paid into any joint account. And the Anambra State Administration, Local Government Administration Law never prescribed that the money from FAAC meant for the local government will be paid into any account in Anambra State. There is no such law. There is no such clause. If there is, I want to see, because the person may be reading a different law, maybe concocted by the social media. Now, let me tell you what the Anambra State Local Government Administration Law says and prescribes. The monies must go into the account from the federal to the local governments. The lacuna created that didn't provide, that the Supreme Court judgment did not provide for the application of such funds, how the funds will be appropriated and to what, and how accountability can be exerted. The law, the Anambra State Local Government Law, now prescribes a pathway for them. And it does so in complete obedience to the express and extant provision of the 1999 Constitution, Section 7 and Section 8. Section 7, subsection 1 says there shall be a democratically elected government for local governments in the states. That was a promise Soludo made that he would fulfill. That's a promise he has kept. Section 7, subsection 1. Section 7, subsection 3 says that the State House of Assembly, not Anambra State House of Assembly, all the state houses of assembly in Nigeria must make a law for the structure, composition, administration, and finance of the local governments in their states. Shall make a law. This is not Soludo saying the 1999 Constitution, even as amended. You can read it. You can Google it. You can find section 7, subsection 3. You can read out and let's see what it says. Even following what you call the community reading, there is no way or where the Supreme Court judgment amended that section that says that state houses of assembly must make a law. In other words, Anambra State House of Assembly made a law to regulate local government administration as prescribed and directed by the 1999 Constitution. Now, is there any expediency in this law at all? Let me tell you the expediency, why the law is inevitable, and why the framers of the 1999 Constitution were actually right and patriotic. Why the framers of the 1999 Constitution inserted that section 7, subsection 3, which imposes a responsibility on the houses of assembly to make a law. Let me tell you why. One, there are common services undertaken by the local governments. Common services. You find the common services in at least 5 areas. One, local government staff salaries. primary school staff salaries, primary health salaries, pensions, gratuities. 5, common services, common to the local governments, not common between the local government and the state. No, because the law never said that they have to pay in any money into the state account. There is no such provision. No such provision. The law says that the local governments will have to set up a joint account to be run by them to take care of their common services. And I have just listed the common services. I have listed the common services. What that means is that the law has simply said, place these services on a first count charge. They have to be what you call not only statutory but also mandatory expenditure that must come before anything else.